families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to this week's episode of Families Divided TV. In this episode, attorney Chris Smith will be speaking with us about family law courts and how they're faced with determining the best interest of the children, but what should happen when dispute allegations of abuse are raised by one part. Attorney Chris Smith argues the need to raise the standard to a clear and convincing standard when a party requests to prevent contact or visitation between the other parent and child. Smith argues that a party should not be allowed to do through a family law case what the state couldn't do through a deprived case. We'll share these thoughts with you in just a minute. We're also going to hear from Dr. Mary Alvarez. She's going to be one of our 11 presenters at our 2.5-day virtual international conference in October. She's going to share with you her thoughts on what she'll be presenting to us, and it's really a great presentation. This is going to be an extremely important conference. This is a very important topic for both professionals as well as alienated family members. We are in registration now, so now's a good time to register. Also, if you haven't subscribed to our YouTube channel, really, it's extremely important for you to do so. We are going to eventually have everything through the YouTube channel. And this way, by subscribing, you're not having to pay anything ever, and you'll get the firsthand knowledge and videos as we prepare them for you. So please take a moment, if you haven't already, and subscribe here to our YouTube channel. We'll be bringing you all of the things with Chris Smith and Dr. Mary Alvarez right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hi, this is Dr. Mary Alvarez. I am a psychologist in Austin, Texas, and do a lot of work in the field of parental alienation. I'm so happy to be part of the 2023 conference this coming year and would like to help you understand my topic, what I will be discussing. So my title is Parental Alienation is a Form of Child Psychological Abuse. And so no longer is this disputed in the field by the experts in parental alienation. And what I would like to illustrate in my talk is how psychological abuse meets the criteria for an adverse childhood experience. And then there's lots of research on adverse childhood experiences and what happens to a child's psychological as well as brain development. And so since parental alienation is considered psychological abuse, then we can extrapolate that the things that happen to children who experience adverse childhood experiences are happening to children who have been influenced by a parent unnecessarily and unduly against the other parent, and that relationship has been interfered and fractured. So we will talk about some of the effects that happen to children currently when one parent is trying to erase the other parent from the child's life, such as the rates of depression, the rates of anxiety, the rates of externalizing behavior, which would be things like conduct problems, oppositional defiance in the child. I'll also discuss with you the role of toxic stress and what happens neurologically to a child's brain development when they are in toxic stress as a result of parental alienation. And the research also underscores what can happen long term to these children, again, both psychologically as well as neurologically. There are some neurological effects that appear to be permanent. And so that's very serious. And my commitment to parental alienation is to reduce those negative outcomes for children through the services that I provide and the educational services that I do. Because while you can't necessarily see what's happening at the time that the child is involved in an alienation situation, the research will illustrate what does happen and what potentially can happen long term. So I look forward to 2023 and invite you to view my conference participation piece. Thank you very much.
Thank you for the opportunity to join you. Thank you to Family Access and Elaine. I appreciate the opportunity to be here and talk a little bit about an issue that is very near and dear to me personally, my practice as a family law attorney in Oklahoma City. My practice is primarily dedicated to custody cases and for fathers and mothers who are fighting to maintain a relationship with their children. I can tell you that there are very few things I believe in the law that are more important than a parent's relationship with their kids. And so we at my practice and my firm, we take this responsibility very seriously as far as trying to protect that relationship. And so when I had the opportunity to talk about this issue, there are a couple of very specific items that I think we can talk about relating to this topic of protecting the parent-child relationship and protecting the rights of parents in family law courts. I want to talk about two things. One of them we're going to elaborate on a little bit more, but I think there are two areas as a family law attorney that I think that we've identified as an industry, and those who are advocates for parental equality and parent-child relationships and who work in the areas that are trying to protect the parent-child relationships that are being torn apart. We've identified, I think, two things. One, we have to do more in terms of our legal framework for creating an expectation for equality. State to state to state, you can look at each state's statutory framework for the parent-child relationship, and it's very hard to find, if not impossible, to find a true presumption that there's going to be an equal relationship between parent and child. A lot of statutes, a lot of states have taken measures to do that. In Oklahoma, 2 years ago, we passed a bill, House bill, that did create a greater expectation for equal access for both children or for both parents as it relates to their children. But we're still seeing just a lack of what I would consider clear expectation for parental equality when it comes to our court system. And so first thing that I think that we have to talk about as a legal framework is going to be that expectation statutorily that there is a 50-50 or an equal right to parent and child for both parents. And so that's the first thing. The second thing is a little bit more esoteric, and it's something that I think is what I want to talk more about today, because I think that there are a lot of people who are advocating for statutory basis. I know that there's been other guests on Family Access that have talked about the need for a statutory presumption for 50-50 time or for shared parenting. So I don't want to go too far down the rabbit hole on that, but I do want to talk about something that I think has become a little bit more apparent when it comes to this issue of how do we protect the parent-child relationship in our family law courts, and that is the presumption or the evidentiary standard used to terminate those relationships. And I'm going to give you an example. Two scenarios. Scenario one, we have an allegation that a parent has abused a child, and the state, through Child Protective Services or whatever the agency is that's tasked with protecting children, has come in, they've taken the child out of the home, placed the child in foster care, potentially, or with a kinship placement, and they have initiated the process of investigating that parent. Through the investigation, there has been a determination that child is deprived, that child is their relationship between parent and child should be terminated. When that case goes to trial and the state is trying to terminate the parent-child relationship, the standard that the court has to use is a clear and convincing standard. Go over to the family law courts, same scenario. You have an allegation of abuse. You have a parent who is being accused. You have an investigation. You have evidence presented. You go to trial. Most states, it's a lesser standard, preponderance of the evidence. And so what is not possible in a state action against a parent right now is possible in many states in a family law courtroom. And so, so I want to lay out a framework for what we in our firm and what I hope that other attorneys around the country will begin to take on in terms of this fight to try to advocate for a heightened standard whenever you're going to terminate a parent-child relationship. And what I'm talking about in a scenario in which you have a parent who has been accused of sexual abuse, they've been accused of abuse, they've been accused of some issue where the request for relief by the other side in a family law courtroom is no contact. Okay, so there's a request for a no contact order in place. And that would be no visitation, no communication, no information. Okay, and that's typically what we would look at a no contact order covering. In that scenario, it's my position, and what I hope will become more clear in the future, is that the court in a family law courtroom should use a clear and convincing evidence standard whenever they're going to de facto terminate a parent-child relationship. If you back up to the actual question of what is the standard here, we all know that, and most people I think understand that a court is going to look, first of all, at what's in the best interest of that child. What is in the best interest of the child as it relates to the parent-child relationship? That's the paramount consideration that any court has to consider. Once we get past that best interest and we get into the issue of what is the relationship between parent and child going to look like, it gets a little bit more labored in terms of what do we do? How do we apply the evidence to the situation? Because I think most courts, most judges especially, are going to say, look, we understand public policy, and most academic literature that is credible would suggest that a child is better served with a relationship with both parents. If we can construct a custody order, a visitation schedule, a parenting plan that includes both parents, we want to do that. In Oklahoma, it's the expectation is that we're going to try to do that. That's the policy that our state has adopted, that if it's not shown to be detrimental to the child, we want to provide both parents with equal access to the child. The question comes with what to do if there is an argument that there's detriment. Okay, so first of all, let's start with the understanding, and I think this is critical to the entire conversation. A relationship between a parent and a child is a fundamental right that has to be considered sacred. And if you look at not so distant constitutional case law from the U.S. Supreme Court, it's accepted that these rights of parents are fundamental, that courts have frequently emphasized the rights of parents as it relates to family, their right to their family, the right to their children. The Supreme Court in the Meyer v. Nebraska case has determined that parental rights are essential, that they should be afforded protections under the 14th Amendment. The Supreme Court has also said that the right to family is a basic civil right of man. That's the Skinner case. In another case that is often cited, the Supreme Court, U.S. Supreme Court, has called the right of parent to a child a right more precious than property rights. So what we're talking about then is, okay, if you're going to take this right away, which we have established through our judicial precedent, that is a fundamental right, it's a civil right, it is a right that is, as one court has said, May versus Anderson, it's a right more precious than a property right. Before you cut that right off and before you take that right away, what do we do? And that's the question that I think has to be discussed as we move forward in this area. Okay, and what we're talking about is this area where we're advocating for parental rights, we're advocating for the protection of father-child, we're advocating for the protection of mother-child. You could even put grandparents in there at some level as far as what we need to look at. So when we're talking about parent-child relationships, we're talking about a right that's fundamental, it's constitutionally protected, that there is a legal bond, not just an emotional and psychological bond between a parent and a child. It should require a heightened expectation as far as how you would go about terminating that right. As we discussed, to start, it's been made clear that before a state actor can come in and terminate a parent-child relationship, they have to establish by clear and convincing evidence that if they don't terminate the relationship, detriment would come to the child. So in the case Santosky versus Kramer, it's a fairly recent U.S. Supreme Court case, that precedent established very clearly that before you as a state actor are going to come in and you're going to terminate a parent's right to visit, see, to do all the things that a parent and a child relationship involves, before you're going to take that away as the state, you have to be able to establish by clear and convincing evidence the detriment would occur if you don't. Where I'm seeing within my practice and within and talking to others is that in family law courtrooms, and what we're talking about are divorces, paternity actions, custody cases, in courtrooms that are not state actor, this is mom versus dad, dad versus mom, courts are applying a preponderance of the evidence standard to the same set of facts that we would deal with in a termination case. So if you're talking about an allegation of abuse and you're asking to terminate, the court in a family law courtroom too often is applying a preponderance of evidence standard to facts to determine that there's a basis for terminating the parent's rights. Why is that important? Why should we even concern ourselves with an evidentiary standard? It's important because when you're in that courtroom and you're arguing that case and you're arguing for your very right to see your children, visit your children, get a photo of your children from school, get information about your kids, when that relationship is on the line, are you going to want to rely upon a lesser standard, which preponderance of the evidence has been determined to be 50-50 plus. Okay, so I've heard it described as if the scales of justice are 50-50 and a feather has landed on one side. That's the preponderance of the evidence. So I think that the case law that we would look at is it's more likely than not that the allegation has occurred. Okay. And it's more likely than not. So you've got an allegation that's been made against you as a parent, and we've talked about. I know that there has been plenty of presentations on this channel about parental alienation. You've got a situation where you have a child who has been placed into a suggestive environment. You've got a situation where you've got an atmosphere of accusation that is swirling around you as a father or as a mother, and that evidence comes in and it's 50-50. Maybe a judge says, look, I can see where this is going to go. I can see where this could go this way, and I can see where this could go this way. Judges have heard these scenarios quite often in many situations, and so we've got a 50-50 scenario, and just you know what? I think that there's just enough that I'm going to go ahead and just say that, Dad, you shouldn't get to see the child. You shouldn't have any contact with your children. That is a very big decision to make. That's a very significant deprivation of a parent's right based on 50-50 plus a little. And what we are advocating for is that because we are talking about a fundamental right, we are talking about a right that is more precious than property. We're asking for a clear and convincing standard to be applied across the board. Before a judge can say, I'm going to take away contact. I'm going to take away contact with the child. I'm going to take away any kind of right to visit that child. I'm going to take away rights to communicate with that child. There should be clear and convincing evidence that it's in that child's best interest. More importantly, there should be evidence that if the court doesn't do it, it would be detrimental to the child. So what we're asking for, and what I think that what needs to be applied across the board, whether it's in Oklahoma, Texas, anywhere where there's a parent-child relationship at stake, there should be a heightened level of expectation in terms of the validity and the right decision being made. And so we're asking for a clear and convincing standard to be applied. Clear and convincing, for those who may not be familiar, means evidence that's highly and substantially more likely to be true than untrue. Okay, so it's going to be more than 50-50. More than 50-50 plus. It's going to be highly substantial. So beyond a reasonable doubt is our highest standard for weighing evidence, and we apply that in criminal cases. Preponderance of the evidence being our lowest standard. Clear and convincing is here in the middle. Highly and substantially more likely to be true than untrue. So a court must at that level be convinced that the allegation being made against the parent is highly probable, that it is not just 50-50 plus, maybe it happened, maybe it didn't, but I'm going to err on the side of it did. It's got to be highly probable that it happened, that there's no question in my mind as a judge, as a jury, however your custody cases are handled in that scenario, that it is more likely and highly and substantially more likely to be true than not. And that's the standard that I believe should be applied across the board when you're talking about terminating a parent-child relationship in a family law court. It's the same standard that's required in terminating parental rights by the state. So the state can't come in and terminate your rights as a parent without that same standard being applied. But in a family law courtroom, right now in most states, those same rights can be terminated with just a preponderance of the evidence. And a preponderance of the evidence can be, it can be anything. So most DHS or CPS protocols that I'm familiar with require that if a child were to disclose evidence of abuse, that they have to substantiate the findings by protocol. They may not believe that the findings, they may not believe the child, they may not believe that the abuse occurred. This may be a scenario where they think there's been undue influence, there's been suggestibility, there's been this atmosphere of accusation around the child, and the child has disclosed something. But because the child has disclosed, there's a requirement based on a protocol that they substantiate. That very substantiated finding, even though suspect, and even though some, DHS or CPS may say, we didn't want to substantiate, the court very well could say, look, preponderance of the evidence, we have a substantiated finding over here, I'm going to find for mom to terminate parent-child relationship. And so I've seen that happen. So if we can heighten that expectation at the family law level, if we can tell our family law courts, you need to apply a higher standard when you are taking away a relationship. Now, I want to be clear. If the court has evidence and suggests, look, I'm concerned about the safety of the child, and they can create a scenario where the parent and child relationship can be maintained safely, then I don't think that it would require that clear and convincing evidence standard, because we're not terminating. We're not de facto terminating. We're not terminating. So if a court is going to say, look, I'm going to give you supervised visits, I'm going to give you an opportunity to reestablish the relationship with your child, I'm going to ask you to jump through some hoops to get back to that relationship with your children, then I think a preponderance of the evidence standard would be appropriate. And I don't think that there's any basis for arguing otherwise, because we're not terminating that parent-child relationship. I'm talking about a very specific scenario in which a family law court says, look, I'm terminating contact. No telephone calls, no telephone contact, no visitation, no supervised visitation, nothing. You're going to pay child support parent, and the other parent is going to have custody, and you're not going to get to see or talk to or get information about your children. I know that sounds to some like that may be a very severe outcome, and one that probably I know there's probably some attorneys right now who are listening to that scenario thinking there's no way that would happen. But I promise you there's plenty of us that would say, yeah, that's happened. And there seems to be a rush in some scenarios within family law courtrooms to say, look, cut off contact, no contact. Well, if there's a specific reason for no contact, and we're doing a no contact order, we're entering a no contact order within an overall plan to rehabilitate the parent-child relationship, that's one thing. But if we're entering a no contact order with no path to rehabilitation of that relationship, we're entering a no contact order that is open-ended with no review date, no opportunity for that parent to come back and develop the relationship that they want with their child or children. If we're entering that order indefinitely, then it should be subject to a heightened level of scrutiny. And that's where the clear and convincing standard would come in. So as we talk about issues of parental alienation, as we talk about issues of parental rights, as we talk about issues of statutory support for parental equality, and we're advocating for the parent-child relationship on both sides to be treated equally. So fathers, mothers, all parents to be treated equally when they go into a family law courtroom. As we're advocating for that, we have to start talking about how courts interpret evidence and what standard is applied, and making sure that before a court is allowed to terminate the parent-child relationship, that court is subject to the same level of scrutiny for that decision, as far as and the same level of evidentiary standard is applied that would be applied in another courtroom down the hall if that parent was having their rights terminated by the state. So that is the issue that I think is probably the most legally, the best opportunity for us as attorneys, for litigants, for parties who are advocating on behalf of parents who are at risk of losing a parent-child relationship. The best opportunity for us is to start developing and testing the evidence against a clear and convincing evidence standard versus a preponderance of the evidence standard. And if you're in a scenario in which you are an attorney representing a litigant who is at risk of losing a relationship with a child, please start advocating for a clear and convincing standard. Please start asking for the court to apply a clear and convincing standard before they entertain a no contact order. Please start asking that we make sure that before we eliminate the parent-child relationship, that we are testing that evidence and applying a more compelling standard to it. So if you are a litigant, if you are a parent who is at risk of losing a relationship with a child, and we know, and this is the thing, we know going into a divorce or a custody trial, we know what the requested relief is going to be in most cases. We know they're going to ask for no contact. We know they're going to ask for the child and the parent-child relationship to be terminated. We may be going into the trial with a temporary order that's already terminated that relationship. So let's start testing the evidence against that heightened standard. And if you're a litigant, make sure that you're looking or asking, let's test it. Let's make the argument to if you're going to terminate my rights to my child, make sure that I'm subject to the same protections and the evidence is subject to the same scrutiny that the evidence would be if the state were coming in and doing it. With that, I think we can start to turn the tide a little bit on some of these pretty egregious cases where we're hearing of parents who are being terminated, who their rights are being terminated in divorce cases, in custody cases, without the evidence that one would expect to see, without the evidence that one would anticipate if you're not going to have a relationship with your child. It's clear, studies conducted have shown that allegations being made within a divorce setting are going to be, they should be subject to more scrutiny. That is not to minimize legitimate allegations of abuse. It is to protect those legitimate allegations of abuse against the illegitimate allegations. And so when we're looking at the scenario where you have a litigant who is attempting to alienate a child, you have a litigant who is attempting to terminate the parent-child relationship of the other parent, those allegations that they're raising should be subject to significant scrutiny, and courts should not allow for parent-child relationships to be terminated based on 50-50, just a little bit more than 50-50. It's too important. It's too important, and it gets me going as far as the issue of what we're doing to protect the rights of parents in family law courts. The first thing we can do is make sure that before we terminate those rights, that those parents are protected and that the evidence that's being presented against them is afforded a heightened standard. Otherwise, judges very easily can say, I'm going to give you supervised visits. I'm going to give you supervised visits. I'm going to let you see. Now, I don't think that the scenario that I've described with a parent who's not receiving any contact, no information, that's a very rare scenario, I hope. But it is a real scenario. And it's a scenario that has happened and will continue to happen. Because there are allegations that are being made every day against parents that are true, and there are allegations that are not true. And sadly, it is easy to err on the side of caution. And when erring on the side of caution, it's likely that good parents who are trying to do the right thing are going to be subject to losing the relationship that they want with their kids. It's in that scenario that we need to make sure that we're testing the evidence that's being presented. And that's where the compelling standard, I think, is necessary. And when we're talking about protecting rights, protecting parents, that's what the evidentiary standard is there to do. It's to make sure that the rights of the litigants are protected. It's there to make sure that before a decision is made by a court, that evidence supports that decision, and that we can be confident in that decision because it's been tested. The higher the right that's being taken away, the more important the right that's being taken away, the higher the standard should be. And if someone can tell me what a more important right is to an individual than a relationship, and we're not just talking about equal parenting time. We're not just talking about an opportunity to communicate and visit the kids. We're talking about a right to have any kind of relationship with the child. If you can tell me one that's more important, I would love to hear it. I think a lot of parents that I know would give up a lot of their rights, whether it be speech, assembly, whatever those rights are. They would give some up to get that relationship with their kids back. And so what we hope is that as we move forward into the coming years and we see more opportunity for dialogue regarding how to apply protections for parents, that this issue will be taken up. When we're talking about statutory and we're talking about legislative initiatives, we talk a lot about equal parenting time, and we talk a lot about opportunities for parents to exercise a split time, 50-50 time, joint custody. We talk a lot about that issue as it relates to new legislation and new bills. We can just as easily make sure that before any kind of parent-child relationship is terminated at any level, there's a clear and convincing evidence standard applied. And I think that will help. That will be a first step. That'll be a first step in helping. Beyond that, there's a whole host of things that other issues as far as education, as far as making sure that our courts are educated as to the issues. And I know that Family Access has done a great job of trying to educate on the issue of parental alienation, changing the narrative and the dialogue around parental alienation and establishing it as a credible and existential threat to the parent-child relationship is a must. The false narrative that parental alienation has been quote unquote debunked is too prevalent in our family law courtrooms. And the argument that there is no such thing as parental alienation is it's hard for me to understand how anyone can put their head around that and make that argument credibly, because I think it's an academically dishonest argument. And so we have to keep educating people across the board as to things that are happening in our family law courtrooms. So I think that covers what I really wanted to talk about. And in closing, I'll say this, this is a very straightforward argument for those who are advocating for this issue. I'm happy to share briefing that we have done in other appellate cases. We have the issue up on appeal right now. We're fighting the fighting for a clear and convincing standard in this scenario in Oklahoma. I'm happy to share the work we've done here with anyone out there that we can help to try to drive this issue forward. But if you keep it simple and make sure that you are presenting your arguments, it's a constitutionally protected right. It's being deprived by the judge. If we're going to take it away, there needs to be a clear and convincing argument. If you can keep it simple and keep it very outlined, I think it's going to help. And so if, as you are out talking to anyone who's interested in the issue of how do we protect the rights of parents in our family law courtrooms, legislation is great, and making sure that we have expectations for parental equality is a first step. But we also need to start talking about the evidence that's being presented and how it's being interpreted by courts, and what the standard of review is in reviewing that evidence by our family law court system. With that, I'm happy to, if you want to talk at any point about any of this, I'm sure we'll have my information associated with the video, but also feel free to reach out to me. My phone number is 405-843-1000, 405-843-1000. I'm happy to talk about this topic and any others that I might be able to help with, because I think it's so important that we start taking back our family law courtrooms so that we're protecting those parent-child relationships. I've said it, I'm on the record as saying it, that I think what our family law courts are doing with families in 100 years, I hope will be looked back on with shame and with just a real sense of, I can't believe that we ever let that happen. And so the only way that's going to change, though, is if we continue to stand up and fight for children and parents, and make sure that we're doing everything we can to try to change the narrative and to advocate on behalf of parents who are trying to do the right thing and children who want to see them. So with that, I leave you with it.
Sadly, too many know the pain and trauma associated with parental and grandparent alienation. Family Access, Fighting for Children's Rights, will present an important international virtual conference on October 13th through the 15th, 2023. Alienation, the Truth Regarding the Trauma and Abuse, will feature world-renowned experts in the field of alienation. You'll join conference event coordinator Elaine Cobb and moderator Dr. Colleen Murray as they introduce you to keynote speaker Dr. Edward Kruk. Plus, you'll hear important presentations from Dr. Joshua Coleman, Lisa Rothfuss, Dr. Mary Alvarez, Dr. Colleen Murray, Bill Eddy, Dr. Noel Hunter, Dr. Sue Kornbluth, Dr. William Burnett, Megan Hunter, and Jordan Traeger. Join the many attendees already securing their spot for the conference, Alienation, the Truth Regarding the Trauma and Abuse. Visit familyaccess.info for all the details. This special conference is being hosted by Family Access, Fighting for Children's Rights, Steel Partners Foundation, and PA is CA. Parental alienation is child abuse.
Next week, our guest will be Jeffrey Morehouse, Executive Director and co-founder of Bring Abducted Children Home. He will be speaking with us on the crime and trauma of international parental child abduction.